for leave to file an appeal without the certified copy. Difficulty is, my lord, this is an appeal by Union of India. Initially, one learned advocate was entrusted to prepare the appeal. There was no progress. At a subsequent stage, we have come. Memorandum is ready, but we find that in connection with a contempt application, the writ file has gone to court number 39. It is not in the department, therefore department is unable to give us the certified copy.
Will you file it?
May I have your lordship's kind leave to file a writ petition state tribunal without certified copy? Your lordship, I'm not aggrieved by any order of the tribunal. The only one order was passed by the learned state administrative tribunal, just the registry orders.
When did you file the matter before the tribunal?
Lordship, in 2025, there are.
When in 25?
I have to check that up.
Check it, then you come.
Your lordship, just 1 minute of your lordship's time. Your lordship, after the tribunal, we filed the original application, the tribunal became non-functional. Thereafter, we filed.
After you filed it.
After we.
Therefore, we are asking you, give us the date. When you have filed it, tell us. Come with that, come tomorrow. Find out the date, let us know, then we'll see.
Great, I'll come back. Great.
Number one. I'm appearing for the petition.
Kindly take it up after a fortnight, my lord. I really require instruction. It's a policy decision completely.
Regarding?
My lord, regarding my lord, the appointment or promotion of my lord teachers, my lord, to the grade of principal.
The learned advocate general appears on behalf.
Number two. I appear on behalf of the appellant, my lord.
Appearing on behalf of the writ petitioner respondent.
Lord.
And I am led by Mr. Aurobindo Chatterjee.
Lord, I am also led by Mr. Somu Majumdar, my lord. If it can be passed over.
Kindly pass over this matter and fix the matter at 12, Lordship, because due to
Mr. Majumdar has not reached, also as my learned senior friend. Leader, so
kindly fix the matter at 12, Lordship. In the meantime.
No, not today. 2 p.m. we have too many matters fixed. We have another bench also. Can't be today. As jointly prayed, list in the next week.
my lord, if it can be passed over.
Call the next.
Entry.
Right.
None appears list after 2 weeks. Taken up. Lawyer gets up that he is not in. It's there.
No, my lord, in three, my lord, I am for the petition appellant, but in compliance with my lord's last order, the other matter has been released from court number 17, the copyrighted matters. My lord was hearing with
Catch your breath. Yes, wait.
Bishas
Ah,
in my lord's presence. But till date, it has not been assigned to my lord's bench.
so it has to be, there is no order of assignment yet.
It was released on 1st August 2026.
Yes. So what should we do? We'll adjourn it for a week. In the meantime, maybe it will be better. 2 weeks. Straight list up. Yeah. What did you get an issued by? Report. Person in charge of registration. Quality. The processing can be done. We are saying that these writers are adversely affected because earlier they had to make out the copy. Now it will be done online. That is the ground to check. Not coming, and it is not an impact. They relied on that. They are not government employees, first of all. They are not government employees. They are not government. They are trained to write the deed. Therefore, they are engaged for writing the deeds. But it is not mandatory. It is to help the litigants. The elected persons or those who cannot be willing to do it on their own. They have no right to as house. Yes. But they are also make copies. Yes.
But in this matter, I am appealing for the appellant led by Mr. Dhiraj Trivedi. But on the last occasion, hearing was almost completed, my lord. To direct us to bring the original copy, departmental inquiry copy, my lord. Can I put it?
The matter was considered.
Because
Give him a copy.
already hearing
There.
completed.
My
thereafter,
my
today
term
he
is not completed. Give me.
Well, okay. Here he is.
Five.
Senior Counsel Udayan Chakraborty is appearing in this matter. Kindly, for the respondent, kindly pass over.
Not today. No Passover in my court. Passover is very confusing. If somebody is watching what
Six.
Item number 6 in this matter, Advocate Siddhartha Shankar Mondal is appearing for the appellant lordship. He is on the way, lordship. Kindly, only 5 minutes pass over, lordship. I am praying for him.
5 minutes pass over.
Yes,
Ah, what a wonderful prayer you are making.
But pursuant to lordship's direction, my lord, I am filing the supplementary affidavit which you have filed, the copies of the same. Copy original to writ petition e file হয়েছিল। Original writ
The report filed in the writ proceeding.
Yes. এটা দিয়ে ওকে বলেছি যে ওই 47 Retired on 31st October. Like a joke. Retired. Why? Husband of Pito, 16,000 Pito. Yeah, Garo. पढ़ाई अपनी अभिष्ट कोई copies of the reports I have found it. আমি দিয়েছি তোমার কাছে ডবল কপি আছে একটা দাও একটা দাও তো What is DPL? Durgapur Projects Limited. The government of West Bengal under. এটা আপনি রাখুন হ্যাঁ আমি দুটো জেরক্স করে দিয়ে দিচ্ছি
This claim, was it considered by any authority earlier? Was the claim considered by any authority? Is there any order passed by the authority?
No, this is the rule, rule which is being followed by DPL.
No.
Was his claim considered by any authority?
No. And Milord, one thing I must point it out, the husband has already retired in the year 2024, 31st October 2024. What is it?
Reply to the application files.
This is what I was asking.
$8.3 crores.
That is quoted here.
Or working. It's approximately. Beyond that distance.
No, that is.
You have challenged this letter of 27/4/22 in the writ court.
My lord.
We asked you and you said no. There is a rejection by you.
That relates to the distance. Yes, tell us.
Well, the issue is that, my lord, the Honorable Trial Court, my lord, directed me to produce the rent receipt. My lord, I have submitted last occasion that admittedly there is no such rent receipt. I have only the, my lord, license agreement, and that is for 11 months. And after 11 months, it is, if they desire, it is, my lord, renewed time to time. Otherwise, it is not. Therefore, there is, and as to why the receipt is not issued, my lord, that is the being afraid of, my lord, creating any tenancy right. And that's why no agreement for tenancy, only the license 11 months, this is issued. Although it is written there, but it is not. No rent receipt they have issued, and is the urban areas in such a manner, my lord, the rented room is, my lord, given. And that I have produced. And my lord, they have said that the two-member committee distance between the husband and wife, that is the 47 kilometers, and two-member committee, that is, my lord, there is no such basis, my lord. They have measured the distance, that 47. We have said that distance between the husband and wife 50 kilometers and above. And they have said only, my lord, in their report, your lordship kindly have a look. That is, my lord, their report, page 3 in the said report, that the area of HRA shall be paid from 10/9/2021, subject to production of rent receipt. Even the agreement is there, they will not but take care of it. As per the company rules, the pending arrears of HRA may be granted from the date of submission of agreement with rent receipt, subject to the condition that lease or license agreement with the landlord regarding HRA mentioning residential address proof and permanent account number, both parties. But all these things have been given except the rent receipt. I do not know whether their rule provides that subject to production of rent receipt, they will consider it, and without the.
Where you are reading?
No, their report, my lord, page 3, my lord.
Yes.
Page 3, paragraph 7, my lord. Only this paragraph is relevant. I do not know, my lord, whether the rule says that without the rent receipt, the HRA cannot be granted.
Let's say that. Anything about rent receipt? Where you are reading that subject to payment of rent receipt?
My lord, that is, I am handing over the copy of the report, my lord.
Paragraph 7, we don't find any such a statement.
My lord, paragraph 7, the area of HRA shall be paid. My lord, got it, this line, paragraph 7, page 3. My lord, this is the, these are the reports filed by them. No, just a. My lord, page 3, paragraph 7, my lord.
This is filed by which authority?
Filed by, my lord, Sujit Shankar Kole. That is report in the form of affidavit of
DPL, the authority, employer. Do you file two reports?
Yes, yes, two reports. After filing the exception, they have filed a supplementary report.
That is pursuant to the order of this court. So about the measurement. That's all.
My lord. And my lord, in my exception, I have dealt with that is at, my lord, paragraph 5, page 2. With regard to the paragraph 5, 6, 7, and 9, I am.
So you are the husband.
No, I am the wife. Shubhra Banerjee has filed this case.
And your husband is in WBSE DCL?
My lord.
No, he was the employee of DPL
Same.
on deputation. On deputation he is in WBSE. So applicability of the clause is not an issue.
My lord, they are only.
Whether you are entitled under the clause, that is the issue.
Yes, my lord. They are only insisting the.
Heard the learned advocate for the
Item 7. Review.
No, Pierce.
I pin down the question with both the authorities and like there's some positive result, my lord. Item 8.
Item number 8, my lord, I am appearing on behalf of the opponent.
My lord, item number 8, my lord, I am for the respondent. My lord, on the last occasion, my lord has directed them to serve the legible copy of the documents they have relied upon. Till date, my lord, they have not served us with the documents.
Why? Why did you not serve?
My lord, he started Passover, that is why I am not
So
certain.
then kindly direct them to serve the copy and let the matter be fixed on any date, my lord.
রিভিউটা যেটা আছে ওটা কার রিভিউটা যেটা আছে না 120 আর 2025 এই রিভিউটা তো রিভিউস তো রিভিউ হবে going into if like the fasting
দুটো কথা হ্যাঁ
so we should add this matter sort of an order asked by another bench. Not required, simply দেখেন আপনার রিভিউটা আছে দেখুন 8
There is a review.
129 225
Legible copy regulation.
129. Which matter we are considering? 8. 8 is a review.
oh sorry I
Nine, my lord, I am appearing for the appellant. But here, the writ petition has been filed challenging the recruitment notice, that is page 53. Page 53. And my lord, page 55 is the notification, and I am challenging the page 57, that is the qualification for direct recruitment for the librarian of rural area. That is name of the post top. Librarian of a sponsored public library having the status of rural area primary unit library. And qualification, my lord, I am challenging that notification for qualification. My lord, this is a qualification for essential, must have passed higher secondary examination or its equivalent and pass certificate in library and information science from any of the following institution. Then such and such institution is there. And then, my lord, second, candidates with bachelor degree in library and information science or equivalent are also eligible to apply. My lord, this is my allegation that second part of this notification, my lord, is not correct at all, because first part must have passed higher secondary examination as well as certificate in library and information science. My lord, we have qualification of passed higher secondary examination as well as, my lord, certificate in library information science, but we have not qualification second criteria, that candidates with bachelor degree in library and information science or equivalent are also eligible to apply. My lord, if they have applied for the said post, then they are got, my lord, more marks from us, because we have only, my lord, certificate in library information, and the candidates bachelor degree, my lord, they have higher qualification from us. For that reason, my lord, this notification has been challenged by the writ petitioner by way of filing writ application, and there was no direction for filing opposition reply, only report exception, and matter has been decided. Because they are higher qualification from us and they already got higher marks from us. For that reason, 30 out of 31 post, my lord, for every candidates, my lord, from candidates of bachelor degree, they got the issuance of the authority issued, my lord, the Bhaibaboshi call letter from that category of people. My lord, we are certificate holder, not bachelor. My lord, here also there was a no criteria for or. My lord, first and second criteria are also eligible. My lord, this is the allegation only before the writ application, and that was, my lord, decided 103, the impugn order. Because, my lord, in earlier recruitment, that was 1997 and 2017, my lord, in the advertised notification, no criteria is there regarding the bachelor of bachelor degree in library and information, as well as in these advertisement, my lord, in earlier notification for recruitment policy, when the government decided to publish the advertisement, whereas wherein also these criteria was no more. And suddenly when the notification of advertisement published, this criteria has been included. If your lordship kindly see the page 61, the recruitment guideline. I also annexed the 1997 recruitment criteria as well as 2017 notification.
So you challenged it after the result was declared?
No, before result. No call letter has been issued. My lord,
You challenged it after participating.
my lord, this was the invite.
Show from your writ petition that you challenged it before making an application. Where you have stated?
As application will be submitted online.
Where you have submitted in the writ petition that you challenged it prior to making an application.
My lord, that was not done.
Then how you can challenge after making an application, after participating?
Not disclosed anywhere because this was only
Terms and conditions, what do you mean not disclosed?
This was, my lord, online application. For that reason, my lord, we did not came to know.
Case.
We did not came to know that this was the additional.
Yes, that is, you may submit additional, you may submit additional.
My lord, all the online application has been submitted. We also, my lord, submitted online application. After that, my lord, before
You are more concerned by the fact that other more eligible persons are participating than your own self.
we had impression.
Once you are trying to raise, employer should not have a higher qualified person.
No call letter issued from the
What about call letter?
this candidate. Only, my lord,
What happened is the recruitment is over.
no, there was already, my lord, vacant post. Out of 31, only 21 has been.
So the recruitment is also over.
My lord, 31 already 10 post has vacant, and my lord,
100 posts vacant. That's not the point. The process is over.
all the recruitment done from the bachelor degree. My lord, as the application made online, my lord, we do not.
Madam Chair.
Your Lordship, in item 10, I am for the appellant, Your Lordship. Inadvertently, Your Lordship, this matter has been filed in Group 6. This is at admission stage, and this is a Group 9 matter, Your Lordship. So leave may be granted to allow to correct the presentation filing form. And there were defects, Your Lordship. We went to the department. Actually, there are no defects because they have raised a query regarding defect of delay. But our CAN 1 is the section 5 application, which is there on record. So there are no defects to that effect.
We are informed that the
Item 11.
11, may I please, Lordship, I am for the appellant lead petitioner. This is my affidavit in reply to the affidavit in opposition filed by the respondent authorities. What happened in this case, my lord? My lord, in this matter, that matter, your lordship already heard the claim. Thereafter, query was issued against my learned friend whether any documents or not. They have filed the opposition, but without annexing any document. My lord, from the any authority reply find. Yes. Who find that the dental point is 11. And the RTC, I mean, my lord, the root canal treatment should not be considered as a, my lord, the well-filled teeth. Opposition. Opposition take to side. Opposition. Vote up. Yes. And, root canal is an artificial denture.
My lord.
The root canal is to be classified as an artificial denture.
My lord.
Where? From where you are saying?
My lord, will kindly come to page 9 of my opposition.
There was. Yes.
It will kindly come to page 9, the second last paragraph
Of your opposition.
of my opposition, my lord. Candidate will be accepted provided there are at least 14 dental points in her mouth, and all these teeth must be sound or repairable. Thus the minimum, the word is repairable, thus the minimum number of points required in the candidature will be 14. So what is repairable, that is also there. Well-filled teeth will be considered as sound. So well-filled teeth, that is specifically stated that will be considered as sound, and nothing else is stated. Thereafter stated, no points will be counted for artificial denture. So anything other than well-filled teeth, if I may interpret it in that manner, is artificial.
Last occasion before your lordship, this argument was raised by my learned friend, and on basis of that argument, your lordship asked where they get this point. Lord, in the medical guideline, there is no sparing about the root canal treatment should be considered as the artificial denture. Even if, my lord, I have one root canal treatment teeth, except that I have more than 14 points. Oh. My lord, kindly come to page 38 of my stay application. It is the order passed by the detailed medical examination board. Let's see. Page 38. Yes. It is a order passed by the detailed medical examination board, founding 13 points of my dental.
That was also not enough.
Not enough. 14 is the required. Malad page 39. Kindly have a look. Malad, this
It has
is the
been
order.
reduced to 11. We
11.
know, but even if we take it as 13,
It is not the Malad.
It is
My
not.
point was that Malad, I have 17, more than 17 point in my dental because one root canal, if I, for the sake of argument, if I left that for counting points, even though I have 17 points. That is all of my submission. And the medical guidelines specifically not mention whether the root canal treatment it should be considered as a artificial denture or not. It is not the artificial. The dent is the tooth is there. On the tooth, it is well filled, and then it installed a cap on the tooth. That is the artificial root canal treatment is talks about. This is the thing. Even if for the sake of argument, I left the teeth for counting the points, also I have 17 points, more than 17 points. That is all of my submission. On that score in different point, Honorable Supreme Court in recent judgment, one of the order appoint the AIMS Delhi to justify the whether I have the retina problem or not. That point
that was a different case.
Yes, here also I am praying what I am praying. Kindly, my learned friend's client also not prejudice. Send me any other dentist or any other institution so that find out whether I have more than 14 or more than 14 dental point or not. It can help me and also my learned friend also.
You claim the review.
Yes, my lord. I only pray before your lordship for any other institution.
After DME, you had claimed for an RME.
RME.
They have not done it on their own.
Yes, that's right. That's right. But the problem is that my allegation is that my dental point has not properly counted.
Yes.
Once they have 13 counted 13, then reduce
judgment.
Judgment. It is with regard to the eye. Honorable Supreme Court was pleased to send the candidate to the AIMS Delhi. আমি আপনাকে ওই দেবাংশ আপনাকে আরো কত দিয়েছি আগে দুবার অন্য মামলাতে AIMS Delhi to ascertain whether the retina problem is there or not, and subsequently that AIMS AIMS Delhi find out that the candidate has no retina problem, then the Honorable Supreme Court was pleased to direct the reconsideration of the candidate. Another point I have taken in the writ petition also, that point, that is the violation of the review medical guideline. Here the instruction given in the review medical guideline that the conformity test and the corroborated the clinical findings and specialist opinion should be corroborated. Here, without obtaining any specialist opinion or conformity test, they have rejected and counted that. That point also not been considered. That's why I am coming before your lordships. It will not prejudice the right of my learned friend's client that if I send for any counting of my dental point, while the innocuous prayer is that, where the also the review medical guideline, where the question about the review medical procedure also is there. That's why I'm praying before your lordships, kindly send me to any other institution so that at ascertain the dental points which I have. My lord, may I submit the review guideline? And another point my lord, must.
What law is laid down?
That is the consideration. I am not praising that law has been settled, my lord. I am not. I am saying that preparatory of the, my lord, consideration of this one. But medical guideline self says that the specialist opinion, clinical findings, and conformity test. Both three, my lord, as because the question of a career of an unemployed youth, my lord, without if
The finding of you having undergone root canal is not in dispute. How it is to be treated, that is the only thing.
Yes.
There is a scope for getting another opinion only if there is any ambiguity.
Here, my lord, the medical guideline is itself in ambiguity because artificial denture does not define that root canal treatment.
Who is saying artificial? Who has said artificial? Nobody
Yes,
has.
but if they have not considered it artificial denture, then
Yeah.
the point should be given to me.
Why?
My lord, it is a root canal treatment, well-filled teeth.
Well
Considering
filled
that-
does not mean filled through a process of root canal. Well filled means a sound tooth, well filled teeth. It does not mean filled through a root canal. Then it is not well filled.
My lord,
Once you have gone through a root canal, where is the question of well filled teeth? It is a tooth which has been made sustainable by going through a procedure. It's not a well filled thing.
root canal procedure also is a procedure to my lord, protect the teeth.
Yes, so it can't come within. There are only two kinds of teeth which are considered admissible. One is well-filled teeth, and the other is if it is not artificial.
Artificial, my lord. That too is, my lord. That's
So
why.
if there are natural teeth with cavities, if there are natural teeth with a root canal, they can't be considered as well-filled.
My lord, that's right.
Even if you had not gone for a root canal, you would have had that cavity.
Yes, my lord, that is not the finding of the review medical.
That is the finding. That is the finding that because RCT it is not a well-filled teeth. That is what they are saying.
My lord, total.
You are saying that once it is filled, it becomes well-filled. That is what you are saying.
No, my lord, that is not. My lord, I am not saying so that my lord, that the root canal should be considered as a well-filled teeth.
Then what
as
are you
it is
saying?
defined, my lord, except that teeth, my lord, that RCT teeth, I have more than 14 points.
Can we
That
go
is-
into the? We cannot.
Well, that's why I am paying before your losses. It is
We
my
cannot
case.
go into that. There is no basis for you to make such a submission.
My lord, only
There is no basis for you to make such a submission.
my lord,
That is a self-serving submission without any foundation.
my lord,
I have sufficient. Everyone will say I have sufficient.
well, the document shows in the writ petition as well as the document says about the rejection order that I have all teeth except one root canal teeth.
Two.
No, my lord, that is the wrong findings of the honorable learned single bench. At that point, I have also taken in this appeal also.
Where is the report? RME?
RME that page, my lord, 38 of my stay application.
7 of the opposition.
Page 38.
39, my lord, 39.
DME is 38
DME is 38.
and RME is
RME
39.
is 39.
Crown plus bridge
Yes.
is placed
45 to 46.
That is
45 to 47. 3 impacted
Smaller.
is noted 28. So therefore 45, 46, 47 and 28. Four teeth. Four teeth have been there is some procedure or the other. How can it be considered a
My
well?
lord, one crown, that is root canal, and one bridge, my lord. That is the two.
Crown is not root canal, sir. Crown is something else. Crown is not a root canal.
My lord, crown is root canal. Is I have.
No, after root canal, crown may be fixed, but without root canal also a crown may be fixed.
Yes. That.
So therefore, it is not necessary that root canal means crown or crown means root
My lord,
canal.
I have annexed that document for my.
We can't
speak
look
to-
into this. We
Well,
can't go
kindly-
into this. There is no
But
basis.
the documents I have annexed that are from the hospital prior to participating the examination, I made this root canal.
You may
One
have.
teeth. That is all of my submission. My lord, except one teeth and one bridge, other teeth for my lord, natural teeth are there.
In the RME, they have found four tooth to be affected.
My lord,
45 to 47 and 28.
that is the my lord, this is my respectful submission.
will say
before
it is
you.
wrong.
This is the wrong.
So therefore, every candidate who comes, we should direct to a third, we have
That
taken
is not-
third.
That is
Done an
not the point,
advocate
my lord.
for
I am my lord, clause 6. Clause 6, my lord, D, next page, my lord, relevant portion is
E,
D.
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 What is there in D which helps you?
Here, my lord, no specialist opinion has been taken from any of the my lord, specialist. Only a test has been done, PGT, X-ray. That my lord, here specifically mentioned the corroboration. Clause 8 also, my lord, kindly have a look. This is very much relevant in this case, my lord. There are a few examples to reiterate and bring home the point that in review medical examination, candidates subject to require concerned investigation wherever and whenever applicable. Rejection merely on clinical finding is to be avoided. This is I am impressing this sentence. Any decision on rejection must be taken up with valid clinical findings, fully justified and supported by corroboratory.
Which one? You are reading
investigation.
which one?
Malad, clause 8 of the review medical examination. Next page, I think. Malad. Clause 8.
What is it?
And moreover, another point, my lord. And another thing is that the opposition pays to clause 2B. Opposition, they have filed pays to clause 2B. It is stated that thereafter may I? It is stated that thereafter the writ petitioner had applied for a review of such medical examination. During the review process, the writ petitioner was subject to medical test from third parties, which confirmed that the petitioner had 11 dental points, copies of the medical report evidencing the same, which have been issued by the third parties appointed by the answering respondent. But that nothing has been done.
That is
That is a misleading and false statement on oath they have taken.
That's all.
Without taking, that's why I am. Is
That's
this a
all.
consideration
Not
of your
a
lordship?
learned advocate for
12.
I'm the appellant, my lord. On the last occasion, my lord had inquired in regard to the PSF rules, my lord. My lord, I'm sorry, rule. I'm not the BSF rules, my lord. RPF rules in regard to the process of recruitment and how somebody goes into training and the probation and everything.
So whether that training is to be merged as a service period or.
Right, there are office orders which specifically says that it cannot be merged, and I'll show the RPF rules first. Thereafter, I'll go to the office orders. May I hand over? I'll just the relevant RPF rules. Rule 49 is the procedure of recruitment.
Part of a circular.
This is part of the RPF rules, my lord. This is the RPF rules in 1987. Now, RPF rules. Railway Protection Force rules.
This does not throw any light on the issue.
Right, may I just point out just one rule and I'll come to the office orders thereafter. Rule 59, this says every person on entering service as a direct recruit in any rank shall undergo an initial training course for the efficient performance of his duties. So after entering service, he goes through a training. But what has to be considered is that whether for the purpose of the benefits under the assured career progression or the modified assured career progression scheme, this has to be considered or not. This has been answered by office orders, these office orders have not even been challenged in the writ petition.
Was considered by the writ court.
This the order has not so I was not there before the learned honorable single bench, my lord. Page 2, my lord, if my lord kindly takes up. This is a 2002 office order. Reference has been received from the constable stating that the date of appointment of constables shown in the seniority list varies from that in the CSR. The matter of having an uniform date of appointment of constables of one batch was taken up for consideration with the policy date, and they have remarked that date of appointment, this is important, date of appointment is to be fixed immediately after completion of 9 months from the date of start of the training. In case of constables in RPF,
Why you are reading something about constables when you are dealing with sub-inspector and inspector? How it will apply, sir?
And even the next
is also regarding constable. And you are talking about pre-appointment training. Here there is an issue of post-appointment training. They are found fit for appointment, they are given an appointment, then they are sent on training. How these provisions will apply? Therefore, we said that this does not throw any light on your submission.
The only thing, my lord, when it comes to there are probably 3 benefits have been given.
One person participates in a recruitment process. He is appointed.
Right.
It is not a unique case. Every appointment in the initial stage is a probation. It is subject to termination without a notice, without complying with principles of natural justice. But upon successful completion, that period does not get obliterated. That period is always merges into the service tenure. You are trying to say that no, this 2 years or these 2 increments earned in that period are not relevant. They are asking you where is the provision. You are showing a provision for constable. He was appointed as a sub-inspector.
And he was discharging now. He is a constable and head constable. That is what the impugned order.
How does it matter what is the provision for constable and head constable? Why not refer to appointment of clerks?
Will kindly come to paragraph 1 of the impugned order for once, my lord. And the petitioners, this is the respondents here, the writ petitioners discharging duties in the post of constable and head constable. This is what the impugned order says.
No, we remember seeing that it was for sub-inspectors.
It was for constables.
Constables. Oh, then that must have been a different case. Anyway, so it is for constable.
Right.
Then you are relying on this provision.
Right. And paragraph 1 of the impugned order also records that They are discharging duties.
So which provision you are relying upon?
Page 2, my lord, the last sentence. The second last sentence, I'm sorry. Date of appointment is to be fixed immediately after completion of 9 months from the start of training in case of constables in RPF, RPSF, irrespective of the date of completion of the training and practical training 9 months. So 9 months training has to be done irrespective of whether the training finishes or not. After 9 months, he has to be. It will be deemed that he has been appointed, irrespective of whether his training period is over or not. The 2002 office order, there are other office orders as well. The very next page, if my lord kindly comes to the circular at the bottom, my lord, with reference to the above, it is stated that in terms of para 9 of the annexed to the board's letter dated such and such, regular service for the purpose of MSCPS, which is relevant here, shall commence from the date of actual joining of the post in entry grade, and pre-appointment training shall not be taken into reckoning for the purpose of MSCPS. What has been claimed here, my lord? The very next page, my lord, page 4.
How it can be a clear?
I'm sorry, extremely sorry, this is slightly marked.
That's a different thing. Provision is something else. She's talking about training. Why this? This is not clear. It's supposed to be. Here, training that training is never after the process you are selected, you are recommended for a yes. But after being declared appointed, there is a period where the status is kept fluid because they will be able to discard you if you don't live up to that. Because till that time, that a permanent appointment or confirmation is by giving a 1 month notice. For training, yes, because they are made signed the form on schedule 6 and 7. Yes, not clear. See what form 6 schedule 6 says. And agree with that point. And I is cannot unless he is appointed. This is under Rule 53.
Schools shall be relying on 89.2, my lord.
See, Evan also has to be signed by. When comes later. What's right to serve? Yes, something like on the right side. Because they are You will have to serve. It's like a bond. You cannot leave for 2 days. If you leave, then you have to pay. Yes,
But I'll also be relying on 94.1 of the rules, my lord. Seniority in the initial grade, it starts there. It is also page 8 of the compilation I just handed over. That is, it is also there. Page 8 of the compilation I just handed over. It's also there.
94.1.
My lord. Interface. I'm sorry, ma'am.
Yes, this clarifies your stand. After completion of, here it is clear. So serve a notice.
I will. The only thing a contempt is pending. It is appearing today before the honorable single bench. That is the only thing, my lord.
What happened?
And it is listed at after 2 p.m. my lord. It is listed before.
Form the learned advocate who is representing the writ petitioner there. You inform him.
I've informed the. He says that he has not received instructions in regard to the appeal. That is why I had to serve.
Therefore, you give him a copy. We are passing the order.
My lord.
The
Third in.
Here I am for the appellant lordship. This is my affidavit of service. Wait, Learned is appearing, lordship. But this is a very short matter, your lordship. But what happened? The petitioner, that is the petitioner before lordship, has filed the writ petition, and that has been dismissed for default. If your lordship kindly come to page 17, prior to going into this impugned order, this was dismissed on 13/5/2026. And on that pretext, very shortly within the period, that is on 18/5/2026, kindly come to page 9, the receipt. This restoration application has been filed.
Where is the initial dismissal order?
Lordship,
Initial dismissal order.
initial dismissal order is at page 17, lordship.
17.
Page 17, 17. 13/5/2000.
2003 matter.
It's a 2003 matter, but one is dismissed, and your lordship knows the latest to
We
be.
don't know anything. You are to inform us. What kind of conduct 2003 matter?
But this is a case of a service matter. What happened, your lordship, in the first round of litigations, what happened that I have stated in paragraph 1, if your lordship kindly see my stay application, he was working as a CISA personal, lordship.
And where is the order passed on restoration? That is the impugned order. 23.
This is the order, impugned order is at page 23. Let it be decided on merit.
What is the issue pending?
But issue is, lordship, he was working as a service.
Don't give us history. What is the issue? Allowing out the proceeding or promotion?
He was dismissed from the service. That
is pending challenge in.
Yes. In the first round of litigation, the Honorable Court was pleased to say there is absolutely misappropriation of the punishment, and it has been remanded back.
He was in which service?
By CISF. It's very unfortunate.
So what will he will do now? He is
still within the age. I have stated. He's still in the age. In paragraph 4, I have stated.
You are representing the railways.
Union of India.
Union of India. Yes.
I just leave up to lordship. Lordship knows within the period and under article. I don't want.
What within what period? There is a limitation in a writ proceeding.
Writ petition, there is a note. Your lordship knows.
What do you mean within the period? There is a
30
question of period in a writ proceeding.
With deepest respect, I humbly submit, lordship, that within 30 days we have already.
Where is that requirement, sir? Every day I find that you are filing a limitation, condemnation, and restoration. Why?
I just leave up to.
Limitation applies to a writ proceeding.
Kindly consider this, lordship. Let it be decided on merit. I just humbly praying before your lordship. But it's a case of a dismissal. It's a
stale matters, you know.
Lordship is not a stale matter. He's still in. He's
were also initially, but 2003 matter. It is
lordship kindly. I pray before lordship. Kindly allow me to.
3 years.
Kindly allow me to argue on merit, lordship. Kindly. Let the petitioner know that I have submitted on merit. If I do not succeed, then this is a different issue. Lordship, kindly, my door should not be ajar on that issue. It is difficult.
Yes, still.
I'm deeply obliged.
14.
Your Lordship, I'm for the respondent.
Will come down anyway.
Your Lordship, I am for the appellant. This matter was taken up yesterday at the end of the board. Your Lordship had directed Mr. Shukanto Chakraborty to appear
Oh, yes.
yesterday. He was there in the morning. His legs in another court. If Your Lordship could pass over or take it up tomorrow, Your Lordship,
Tomorrow
the
we'll-
main issue involved over here.
No, we had, please ask him what transpired on the last day.
Your Lordship,
We'll take it up tomorrow, whatever has to.
wait for it.
Not today. You can inform, amongst you can inform.
Your Lordship, I had informed him, Your Lordship.
No, what happened on the last day, you please.
I have already indicated.
Not here, not here.
Your Lordship, in this matter, there was a representation which had to be disposed of within 8 weeks. We had preferred an appeal on the order of dismissal. Your Lordship, I have taken instructions, written instructions. They are seeking 1 more month's time to dispose of the. This is
Then
the,
what remains?
Your Lordship.
Dispose of the. So why you are saying about?
Your Lordship had directed a senior to appear, so it's my duty to inform Your Lordship. There are two copies of the instruction.
This is precisely what we were of the opinion on that day, that, what is the issue pending? There's nothing pending.
The representation for the admitted dues had to be paid. Your Lordship, page 159 is in the stay application is the impugned order under challenge.
The 11th of May 2026.
Paragraph number 8, the Honorable Court had directed within 8 weeks.
So appeal is still pending.
Your Lordship is in hearing. Your Lordship is only
That
hearing
appeal
the
has been
matter.
kept in the month of September. Paper book has been directed. There is no interim protection in favor of.
No, that appeal is pending.
Yes,
Your Lordship.
appeal is pending.
What was the punishment awarded?
Your Lordship, dismissal. Order of dismissal was.
So what he will get?
The Honorable Court had directed in the 24th November
What
order.
are the dues admitted in the meantime?
Your Lordship, meantime, the admitted dues would be because PF, on account of PF, he was covered under a new pension scheme, so he has to make an application before the new pension
Deposit
scheme.
is there.
Your Lordship, and on account of gratuity, nothing will be payable. There would be some amount payable on account of leave encashment.
Even cashment, there may be some group insurance or something like that.
Lordship, whatever for that they have asked for 1 month's extension. That time may be granted by this
Yes, take
Honorable
down.
Court.
Have been filed by an application. It could have been, but it is now that it is staged. Okay. We have filed. It could have been done in that. Because that is when you will get that's
And in this case, the writ petition was summarily dismissed by the writ court without exchanging any affidavit. Well,
Where is the bar?
I am not praising that there is no bar.
Then this is a point can be asked by the Union of India. What is your grievance?
My lord, Lordship, in this case, my lord, Lordship kindly come to what is that charge and what is the allegation against me?
Yes.
My lord,
that he has more than one wife, several wives.
the allegation is this that the petitioner contact my lord taken marriage without having his wife existed.
Yes.
That is the only charge against him. My lord, thereafter departmental proceeding was started against him and it was culminated with the order of removal from service. Petitioner preferred an appeal. That appeal was also rejected. Thereafter, my lord, petitioner moved the writ petition before this honorable court. Annexed P4 of the order of this honorable court, whereby the learned trial judge, my lord, set aside the entire departmental proceeding, given liberty to the departmental authority to proceed from the stage of charge sheet. On the basis of that order,
Charge sheet was not interfered with.
charge sheet not was, charge sheet is
Very well.
existed. On the basis of that order, my lord, the petitioner was again proceeded with, and my lord, again he was, my lord, held guilty, and he was removed from service. My lord, before my lord passing the impugned order of removal from service, no show cause notice was given to him, and he was not served with the order of the inquiry officer.
Order of the?
Inquiry officer. Of the inquiry officer.
So inquiry was conducted.
My lord?
Inquiry was
Conducted, yes.
But show cause not given.
The show cause and the findings of the inquiry officer was
Obviously. So it is a normally a composite exercise, show cause along with copy of the inquiry report.
Yes.
That was not done.
done. Again, my lord, he moved the writ petition, and my lord, the writ court directed the concerned authority to serve the copy of the findings of the inquiry officer along with the show cause notice. Now, my lord, kindly come to page 77, annex P16. This is the show cause notice. 77.
Yes.
All right. You have acknowledged this office letter number such and such, wherein you was ordered to report to your post immediately to give effect to the honorable court's order and the appellate's order, and this office DO number such and such. A copy of the appellate order was enclosed in the order of the appellate authority was passed. You have reported to your post, and from that date you have been placed under suspension as per the appellate authority. In compliance of the order of the appellate's order of IG Chief Security Commissioner and the order dated such and such passed by the Honorable Justice Aniruddha Bose of Honorable High Court, Calcutta in WP number Ato. The copy of the findings
No,
of the
page 77, we don't find it.
no,
Which page?
Page 77.
Of the paper
My lord,
book.
difficulties is this. My lord, I am sorry. My lord, I have lost my paper book. That is why, my lord, I am placing my case on the stay application.
How we can do it? It will become very difficult.
My lord,
It will be difficult for you and us, both of us.
I could not find, my lord, I tried my best, but I could not find my paper book. That is the difficulty.
I can go through the.
Lordship, kindly,
No, he can get a copy.
my lord, your lordship paper book, my lord, if it is, my lord, I will, my lord, Xerox, get it Xerox.
I hope there is no notes in this. Let him get it. There's nothing in mind. Perhaps nothing in this. The learned advocate for the
I was asked to take instructions. Why it was her medical test was taken in 2000, appointment 2007. Lordship, the respondents here are from the place where she retired. She had retired from Purva Bardhaman, Lordship.
so she's a retired person.
Yes, she was appointed in Birbhum. So we are pursuing with Birbhum to get the instructions for the delay appointment, what happened exactly. Therefore, Lordship will kindly give us some time in the matter.
You did not appear on the last day.
I did. Lordship,
On 30th July?
no, 30th July, I didn't appear. Lordship, 30th July.
Just show this one.
I had, because my notice. This is again demand. Yes, demand.
So accordingly, as prayed by the learned AG,
Item 17.
17, Lordship, and for the appellant. Lordship, the new incumbent has come, Lordship, so kindly give me 2 weeks time to take instruction from my client.
new incumbent.
Lordship.
18th, Amit Amol.
Jivan Kumar Ganguly.
17 I have bank.
Sir, it is content.
No, I think she is not.
Something is wrong somewhere. 1814. Yes.
Sorry, Lordship, pardon.
We thought so, yes. You are appearing
No, I
for
am
the
appearing
appellant.
for the bank.
You are for
Bank.
appellant.
For the bank.
No, I am appealing for the bank, respondent.
My lord, I indicate to your lordship, my lord, this is the disciplinary proceeding matter, dismissal from service.
So you are for the appellant. Yes.
But I am only requesting your lordship. Justice. My lord, I am only requesting your lordship. I can take it up sometime later. My lord,
You have to start now. Lordship is not inclined to grant an adjournment. To start.
next.
Lordship is not inclined to grant the adjournment. I will not differ. I will not differ on the ground of adjournment.
Lordship is not inclined for, my lord, this is my maiden appearance before his lordship, that's why maybe.
Your lordship may do it.
Your lordship will kindly keep it, my lord, next week after next, my lord.
All right with you. As prayed, list after.
My lord, for item number 18, 19 and 21 to 23, I'm praying for not this week, my lord. The learned advocate. 18, 19.
No, একসাথে সবগুলো
18, 19.
There are from 18 to 23, the matches have to be taken up together.
You want 1 week's adjournment?
Yes, my lord, 1 week, sir.
You're for the writ petitioners.
Read petitioner for item number 18, 19 and from 21 to 23. For item number 20, they are for the petitioner.
There is a prayer for adjournment on.
And 24 and 25.
Thank you.
আগের অর্ডারটা বের করো 5226 5226 না এটা 1390 এর আগেরটা যেটা লিবার্টি দিয়েছি
Yes.
First of all, I like to place the impugn order, Lordship, for which I prefer this application. Which is annexed at page 223 of my volume 2, Lordship. No, 5226.
Which page, volume 2?
Lordship, page 223 of volume 2.
Oh, where is the court's order impugned?
Impugned order, Lordship.
Read court's order.
Read court's order. This is the read court order.
Page 223.
223.
R5. Volume 2.
Volume 2, Lordship. No, no, volume 2. But it is satisfied. Lordship, may I please?
223 is R5, sir. It is not the impugned order. Here, see, look here.
No, no, the 2 volume. The impugned order.
In fact, we should be irritated. You are getting irritated.
No, no, Lordship.
472.
472, Lordship. FMA 472, volume 2.
FMA 472. There are two matters.
There are two analogous matters.
Tell us, unless you tell us how we will know, sir.
Second matter has 5 volumes, Lordship.
This is the order under appeal. 13 September 2019 order.
13 September 2019, Lordship.
Yes. So that same relief which was declined, you have raised again.
Yes, my submission is that, Lordship.
No, we are not yet reaching the stage of submission. We are on facts.
Lordship.
So the same relief and was rejected by the Red Court,
Lordship.
traveled up to the Supreme Court, you failed,
Lordship.
you were transferred somewhere else. From there, you raised the same issue again.
I raised the issue when I was posted in Kolkata, Lordship.
You raised the same issue again.
Lordship.
So then that will give you a fresh cause of action because now it has again been rejected.
As because the government issued one advisory in the year 2019 to the bank to redress my grievances.
So therefore, every time you raise, so after we dispose again, you can do it again.
No.
Why not?
Honorable Apex Court doesn't consider with the facts and merits, they dismissed on a simple word that hard and dismissed. But Lordship,
so
if my merit,
what does that
my cause of action died at that point.
When you say something, it should be having some consequence.
Lordship.
So hard dismiss, what does that mean? So what do you want to say to us?
If my grievances died at that point of time, Lordship, but it was subsequently retrieved when the government issued one advice.
So therefore, we are saying after we dispose of the present matter, again you can move
And if the government passes an order, then again you will file a writ petition.
If my
Who will prevent you? Why stop at 2? That we are wondering.
lordship, that I cannot say in.
No, you are here to assist the court.
Yes, lordship.
Is this the way?
Lordship. I
Is this
try,
the way?
I try to my level best to assist.
There is the question of level base, where the question of fresh cause of action. Forget about territorial jurisdiction, Nabil Kishore Sharma judgment, all that. Where is the question of a fresh cause of action?
If
So every time the court rejects, you will come up with a new representation and that will give cause of action.
This time the court was not reject for the first time, lordship. When for non-compliance of the government advisory by the bank authority, I prefer writ application before this honorable court for a direction that
What is the worth of this advisory?
To redress my grievances, lordship.
So what is the worth of this advisory?
Lordship, as because there was a manipulation
Let
of
them give an
indexes.
advisory. The bank will not decide. How can you enforce it?
But I cannot. I am not stating to comply that advisory.
Just now you said because advisory was given, we have
Government
to.
issued that advisory to the bank. Government issued the advisory to the bank. To
How
take
many
this
times you will say the same thing? You have said that because advisory was issued, I have come. So we are asking you, what is the worth of this advisory?
Sure, lordship, they are duty bound to comply over that.
Under which provision we are asking you?
Lordship, that is the main fact. As the scheme of amalgamation was violated by the bank authority for the promotion and interstate seniority, lordship. They manipulated the interstate seniority as
We are not going to go into that. You have to get over the hurdle of maintainability. Don't think that we are going into the merits.
No, lordship.
Two issues you have to address. How a fresh cause of action you can claim because it was again raised by you.
It was not raised by me. The issue reinstated by the government of India to the bank
on its own.
On its own. As because I made representation since 2007. I made representation since 2007, lordship, and they admitted it.
I think the making such submission helps your client. Please come clear. Don't beat around the bush.
Lordship.
That is not going to help him or her, whoever it is. We don't. The issue is very simple. Issue was considered by the court, traveled up to the Supreme Court. You are trying to raise before us that it was heard dismissed. So, first, what is the consequence of that submission? Secondly, even if an advisory has been issued subsequently on some pending representation, that will give rise to a fresh cause of action. First thing you have to answer is this. Secondly, whether the issue of territorial jurisdiction is satisfied by Naval Kishore Sharma. How do you say it is satisfied? Because that representation was sent when you were still in Calcutta.
Lordship.
Wonderful. So it appears you are more interested in litigating. We'll consider. We are coming back.
My lord, item number 1, I am for the appellant, and item number 2, I am the respondent.
Item number,
Item number 2, I am the respondent.
item number 2, 1 is the I am the respondent's writ petitioner, 2 is the I am the appellant, cross appeal. This is the case for my interest. My appeal regarding interest. And
And-
appeal is in first truth.
No, my lord. In this matter, the facts are different.
What is the fact?
My lord, in Maya Bauri matter, the writ petitioner died in harness, whereas I have prayed before my lord that the employee did not die in harness. The ex-employee. The legal heirs have come before the honorable court praying for monetary compensation along with interest. Honorable single judge was pleased to refuse the interest part, granted payment of.
He did not die in harness.
Yes, that is my submission.
That is there in
My lord, and primarily the matter was not heard before the honorable single bench. It was mentioned that
That
it
is
was
not primarily. First, tell us whether he died in harness or not.
no, he didn't die in harness. It shall appear from the writ petition itself.
Where is this statement in your appeal?
Yes.
My lord, in appeal, I have mentioned that my matter was not heard. It was taken up. The matter could not be assessed for consideration. It brought up before the honorable court, filing writ petition, and thereafter the matter was decided on a single day on the plea that it is covered under my above.
Again, we are asking you, where have you stated that he did not die in harness?
My lord. Kindly comes.
Memo.
One second.
None of the paragraphs.
My lord, here I have filed my counter affidavit in this matter where the interest has been claimed.
Please show us that statement of fact that he did not die in harness.
Yes. Yes. My lord, page 15 of my counter affidavit, my lord. Page 15, paragraph 11. May I, my lord? I most humbly submit and state that the writ petitioner appellant is neither entitled to MMCC nor area nor any interest. As such, the writ petitioner is not eligible to apply for the same under the died while in service category.
Again, we are asking. We are not asking about her eligibility. You made a statement of fact. Unless your client has stated so, how can you make such a statement?
My lord, writ petition itself would say he was not in service.
Madam, you have filed a counter, you have filed an appeal.
Yes.
If there is no such a statement, how as a lawyer you can make this statement which your client has not made? To defeat this person's claim for compassionate appointment and monetary compensation.
My lord, may I show one document?
No, you will not. Why you make such a statement of fact, contrary to the record? You are trying to distinguish your case from all the other cases in which you have considered as an employer. And the only ground for making an exception is a statement of fact contrary to the record. Very unfortunate.
That's the least we can say. This is not the way. We should be able to rely on what you say. I knew it was not there, therefore I asked you to show. That's not your client's case.
My lord, may I please, my lord, kindly allows. The particular page upon which I have made this statement, my lord, I want to rely on that page from the writ petition only.
We have been waiting for you to show that statement. Till now, you have not shown it.
My lord. My lord, here I have mentioned the facts, my lord, not in the appeal as my lord has correctly pointed out, my lord, but in the counter affidavit I have written what was the, my lord, may I?
We are just wanting you to point out that one statement that he did not die in harness. You made a specific assertion. It is supported by which government? Because we said your repeal is infructuous. The employer has given a undertaking before us that yes, we will make payment of all these matters from the date of death. So therefore, yes, we said your appeal is also infructuous like the others. You said no. There is a great distinction because here he did not die in harness. Now, where is that statement?
My lord, kindly allows me to read one paragraph where I.
Nothing. You show that statement. How you can make such a statement, madam, as a lawyer? You think I have not been there?
Only refrain from imposing a cause because we know that you will chase him to the higher forum. Therefore,
No. I shall not go for that, my lord. I am relying upon my lords only. Yeah, I leave it to my lords.
just see the pathetic condition, ma'am.
My lord,
Just
but
see.
my lord, I
Having to
understand.
work at a construction site, and you are saying he was employed elsewhere. And this is an objection you are raising to defeat his claim.
My lord, if he was under treatment under the company's hospitals, this would not have arrived. My lord, this is a private doctor who is certifying that he is ill, my lord. That is the reason. He didn't join. He would have joined if he was under treatment with the company's hospital, lots of hospitals. Initially, he was referred to one of such hospitals. Thereafter, that is a hospital under the authority only.
So he was admitted there.
Yes, and thereafter he didn't join, my lord. That is
He joined. He is seriously ill.
No.
He is admitted in the hospital. Just see. I was admitted to CH Kala from such and such date to such and such date.
Yes.
What yes? Come and read the bottom of the third paragraph. You are missing all the facts. You are saying he never went to the company hospital. He was admitted there.
But the doctor here in the third paragraph is not the company's hospital doctor, my lord.
Madam, it says CH Kala. We just asked you. You said it is the organization's hospital.
My lord, firstly he was under diagnosis of TB. That is what he is being given Koraki for TB.
What you are trying to make out? What case we don't know.
My lord, I shall not make any.
He should not have been ill. He should not have suffered from TB. He should not have been admitted. Because he fell ill, because he had TB, because he was admitted, we will not give him any. Well, you can say anything.
My lord, I'm only saying.
Workmen, the dues that they are claiming is under NCWA. NCWA is akin to a bipartite settlement enforceable under Section 18 of the Industrial Disputes Act, and in every case we are having to do the same thing, pass an order.
My lord, this is the first time, not the first time he is doing such absenteeism, my lord. In my counter affidavit, I have submitted from 2003 to 2012. The chart, page 10 of my counter affidavit, my lord, I have given a chart about his attendance. He is a regular absentee.
This is the only one.
My lord, kindly see the letter dated which my learned friend referred 12th October and he died, my lord, 21st October.
Give us a list of dates.
My lord.
Give us a list of dates.
My lord.
Giving all these periods in one piece of paper.
Yes, my lord.
File it. Pass the order because they will not pay like this.
None of whatever my learned friend is saying, none of them are the pleading either in the
yes. Let them fight. It's not there, then
the family of the petitioner is suffering.
Don't travel beyond the pleading and the petition.
My lord, as my lord shall.
Yes.
And I shall submit a list of dates as my lord has.
Learned advocate for the
next one.
close it off on that.
Covid date?
7th August. Give a date after. Need date. Give a date after.
Lord, shall I produce the Mayabari judgment? I have copy.
You have a copy?
Yes, my lord.
The one we have passed recently?
Yes. Just give us one copy, please. Do two. Darshak Kadim. And everything has been covered by your lordship here. Yes, I know. Yes. We have the author of that. Deep.
Deeply.
We are asking for the division bench.
Yes, my lord. Division bench I have given.
This is the single judge.
No, no, my lord. This is your lordship's order.
This is the single judge.
I'm sorry. Extremely sorry. I'm extremely sorry. What a single. I'm sorry. Yes. I'm getting.
Keep your testimony. Hey, Nam. Yes. Excellent.
Item number 3.
And I am for the petition.
My lord, if your lordships allow me, my lord, I have a common submission for both of us.
Yes.
That you, if your lordships kindly take it up next week. There is a common submission. For a reason, my learned friend knows I do not want to submit that reason in open court.
Reason is, my lord,
Reason is bona fide.
My lord, some program is organized on
please, not in
15th
court.
August. He is in charge of that.
Then we'll take it up on the. We have fixed those matters after 2 weeks that day only. Same day.
I'm sorry to make this
Jointly
submission.
create this form.
Excuse me. I'm sorry to deeply.
Grateful, my lord.
Weeks. And we pay order as jointly created this form with the same day.
Number 4.
Lord, I appear on behalf of the petitioner.
I'm for the respondent, Lordship, led by Mr. Partha Ghosh.
My Lord, in this matter, your Lordship was pleased to take up on, my Lord, 23rd April 26. And your Lordship was pleased to give me a direction, my Lord, to file one document which was missing. That was the appointment of the inquiry committee. That document was missing, my Lord. I have disclosed that document by filing a supplementary affidavit. May I hand over that supplementary affidavit to your Lordship? My Lord, that page 9 is that relevant document. That is the only document. So follow me. My Lord, may I file that supplementary?
স্ট্যান্ডিং কমিটি মিটিং ছিল
হ্যাঁ ওই একটাই তো বলেছিল ডকুমেন্টটা
Page 9.
Page 9. That's the only document.
Yes.
My lord, in this appeal, my lord, I have taken 3 points. My lord, the first point was that this honorable court doesn't have the territorial jurisdiction, as the no part of the cause of action has arisen within the territory of this honorable court. Well, second was on the point of delay, and third was, my lord, on the merit. So, my lord, while first day I was submitting before your lordship, came across the reference of this document and asked me to disclose that document. Now, may I tell your lordship in the matter, the petitioner has come before this court after 23 years, claiming that he was deprived to have the promotion, and he made a representation 1 month before the filing of the writ petition, and then, my lord, filed that writ petition. My lord, at the motion stage, the writ petition was disposed of. My learned advocate on record was also present at that time. My lord, amongst others, the point of jurisdiction is the first point, my lord, I have taken. My lord, now may I hand over your lordship?
Did you file an opposition?
My lord, I didn't have that scope either. My lord, may I hand over your lordship a list of dates, my lord? Very short list of dates.
Give him a copy.
Yes, definitely. My lord, kindly excuse me, my lord, the last date, my lord, is handwritten. Petitioner was regularized as junior mining engineer by a memorandum issued by senior personnel officer Dhanbad. Criminal complaint made by DGMS Dhanbad, Jharkhand, and filed before the Chief Judicial Magistrate Court at Dhanbad. Charge sheet issued by CMD BCCL Dhanbad. Reply to charge sheet given by the writ petitioner Dhanbad. Inquiry officer was appointed by CMD Dhanbad. Inquiry report, a report of inquiry officer submitted to the BCCL Dhanbad. Petitioner was asked by senior manager Dhanbad to submit EER report immediately. Then 17 January 26, Press Inquiry Committee was appointed by Director BCCL Dhanbad. So, lordship will find that the entire thing is at Dhanbad. He was appointed there, he was carrying on, he was working there, and everything was done in Dhanbad. Now, my lord, he has filed this writ petition in this court, and by making up pleading in the writ petition that since CIL's office is situated in Calcutta, that is why I have filed the writ in this writ petition. My lord, if your lordships kindly come to paragraph 23 of the writ petition, I have annexed the writ petition. Writ petition from page 37. Page 37 and paragraph 23 of that writ petition.
Where is the writ petition? Where is the writ petition?
State petition, the annex. But the writ petition starts from page 37, but at page 50, page 50, paragraph 23. Your petitioner submits that the instant petition is fundamentally sought to be moved for not granting promotion by CIL, as the petitioner being direct executive employed by CIL and his promotion etc. is under the domain of CIL. The office of CIL is within the territorial jurisdiction of this court, and the writ petition is maintainable under the jurisdiction of this honorable court. So this is his pleading, and on that basis, Ballard, he has filed a writ petition. We have stated that the jurisdiction, if any, is the Ranchi High Court, not the Calcutta High Court. Ballard, if your lordships now kindly take the impugned order, the learned trial judge has only dealt with this jurisdiction point. My lord, kindly sees. The point of jurisdiction was taken, but at this verbally it was argued, and my lord, learned trial judge has not at all.
Where is your submission regarding this?
My lord, paragraph 3 of the judgment. It is submitted on behalf of the Coal India and BCCL that a criminal proceeding was also initiated against one outstanding, and therefore it, A.K. Sengupta, 5 others before the jurisdiction of Chief Judicial Magistrate, and next date is on so-and-so. It is contained on behalf of the respondent. The petition is one of the accused in criminal proceeding. Then, my lord, in paragraph 4, we have stated that the inquiry proceedings had initiated, inquiry proceeding is there, and it is submitted. And then, my lord, inquiry officer and everything was given, and হেল্প করে হেল্প করবি তো তারপরে দাঁড়িয়ে থাকলে হবে page 5, if your lord please kindly see page 5.
Yes.
Of the therefore there is no jurisdiction on withholding, but this is with regard to the promotion withholding.
Yes, you have not raised it anyway.
No, I have not.
It's an issue of jurisdiction. We have not found it in the judgment.
Issue of jurisdiction, my lord. No, it is not there. It is not there. My lord, this is the specific point what I have.
It is a point of jurisdiction. It can be considered at any time.
At any stage. Any stage. And my lord, also the point of delay. My lord, on the point of delay, my lord, if your lordship kindly takes paragraph 14 to 18 of the writ.
When it became due to you according to
My lord,
when the promotion became due
23 years back at their own admission, they say.
What is which year?
Well, 2003. According to them, they became eligible to get the promotion in 2003.
Which date, sir? We are asking.
No date is mentioned in that. They themselves have said it is 2003. So if it is 2003, after the charge sheet was issued.
That date. That's why we are saying that date is relevant.
Yes.
If it was after the charge sheet or charge memo, the situation will be different. It was prior to issuance of the charge sheet or charge memo in the proceeding.
It was charge sheet was issued on October 2003.
So what is the date on which he became eligible? That is relevant.
Yes, my lord. May I kindly show your lordship? Kindly come to paragraph. Kindly 18. Sorry, paragraph 17, page 11. Paragraph 17, page 11. Page 47, my lord, kindly come page 47 of that stay petition. Your petitioner states that he had submitted a representation on July 24 before the jail manager Coal India Limited and said representation was duly forwarded through email communication dated 24, inter alia paying for consideration of his promotion strictly on the basis of seniority. It is humbly submitted that despite rendering long service, the petitioner has been denied promotion for the last 23 years. on the purported ground of a disciplinary proceeding initiated him by charge sheet dated October 2023, 31st October 2023. So therefore, his promotion, if any, well, the exact date I cannot say because I don't find, nor they have said so, but it is a year 2023. They, according to them, they became eligible. My question is that if he was eligible in 2003, he would have been taken some steps, some agitation. He could have come before the authority, he come before the court that I am being denied. He sat tight over the matter, and only in 2025 made one representation before the CIL and filed the writ petition thereafter. So that is why I have also taken the point of delay. So if your lordship accepts my first point at the point of jurisdiction, then all other points, comes later. So far as the jurisdiction is concerned, my lord, first of all knows that Article 226(2) is absolutely clear. Either it is the whole cause of action or the part of the cause of action. From the writ petition itself, it cannot show that any part of the cause of action has arisen within the.
Have the judgment, Kishore Sharma judgment.
I have that is the 2023 volume 7 SCC, the judgment law. Two judgments I am relying on this. Uh, 2023 volume 7 SCC 791. The বইটা লো। একটা আরেকটা দাও। হ্যাঁ নিশ্চয়।
Is there any reference to Naval Kishore Sharma's judgment in this?
Must be there. I just please, brother, you don't have a copy. Okay, don't have a copy. No, actually, that's a radio estimate. Well, the paragraph 15, 17 and 18, well, these are the three relevant paragraphs. Okay. And statement in paragraph 18, the court has come to the no integral part of the cause of action has arisen within the jurisdiction. That is the point to be taken into consideration. So therefore, admitted, they are showing from their own pleading that no integral part of the cause of action has arisen within the jurisdiction. But the second judgment on this issue, judgment reported in 2007, volume 11 SCC 335. Paragraph 20 and 25. Right? Hey, 2007 volume 11. এটা কত দিয়েছো? 9 দিয়েছো না?
Sharma, it was clarified that it must be the same like. He taken was that some order is communicated such as such. Supreme Court said that the correction order does not a matter. Facts based on this dispute rests. The fact that the communication in some case is not in dispute is not part of the Fish is saying that an office is situated there.
আমার কপিটা নেই আমার কপিও নেই
Not my own teacher. That is if I
Also, from the jurisdiction point, I am making, if your lordship is not with me, then my lord, I will go to the other point.
Practice, my lord, the inquiry. Inquiry was closed way back in 2003.
Where is the closure of the inquiry? By which order?
My lord.
Page 107, inquiry officer's report.
Please,
No, that is
let
the-
him,
Yes,
please, yes.
107, my lord.
No, that is inquiry report.
Yes. Thereafter, they kept the matter pending.
You said it was closed.
So, my lord, kindly see at the bottom.
107.
Yes.
Last paragraph.
Last paragraph. In view of the above position, I feels that the inquiry has been deadlocked and cannot be proceeded further. He has therefore no option but to close the inquiry at this very stage, and the case may be forwarded to the disciplinary authority CMD BCCL for taking a view
Correct.
in the
So
matter.
this is not a closure. This is the inquiry officer's disability to proceed further, referring it to the disciplinary authority.
So thereafter, my lord, what's
But before that, an issue of jurisdiction.
my lord?
What
Yeah,
is
my lord.
that cause of action? What is that event?
Yes. Now, my lord,
Placed within the territorial jurisdiction of
now,
this
my lord,
court.
I am the officer under the Coal India Limited. I was posted at BCCL, that is at Dhanbad, beyond the jurisdiction of Calcutta High Court. Now, my lord, my promotion is to be granted by the Coal India Limited, not by the BCCL. Now, if you will kindly come, page 108A.
108.
108A, this is type copy.
Yes.
A. You are once again requested to submit this thing immediately, as well remanded by CRC and Coal India, within the territorial jurisdiction of this honorable court, for this for consideration of your case of promotion to the grade. So Coal India is the only authority to grant me the promotion. BCCL cannot. I have, my lord, the two forums. I can go, my lord, at the Jharkhand. I can also, my lord, choose Calcutta High Court. Now, next page, if you will kindly see, based on this document, they have to give me promotion, page 109. Human Resource Information System issued by the Coal India Limited.
What is issued?
My lord, page 109.
Yes.
Then, my lord, prepares the executive profile and executive summary for the purpose of promotion. Kindly see page 109. This is my document issued by the Coal India. Your lordship will find from the top Coal India. Now, next document, my lord, your lordship will find page 112. This is the promotion order issued in favor of the petitioner from the Coal India in 2013. Coal India is the only authority. And my lord, that's why they never, my lord, raised this point before the trial court. Series of hearing took place. series of hearing took place.
He is saying that on the
No,
stage.
let this show, my lord, from the document, from the orders they have raised. Now they are believing that they have.
Writ record is here. No, the writ record. Writ record is here. Writ record.
Huh?
It does not come with the appeal. It should have been.
At my initial stage of appointment.
Whether these are the facts in issue, whether this constitutes a part of the bundle of facts requisite for your promotion.
Promotion is to be granted by the
Office
collegiate.
is in Calcutta. That is not a relevant fact for your promotion.
But not only the office, the chairman come managing director of the Coal India sits at Kolkata. So he has to grant the promotion. He is the signatory authority.
Very well. You may say so.
So, my lord, unless my lord, Coal India is my lord, that's why the trial court, if you will find, the trial court directed the BCCL as well as Coal India to grant promotion. Please see, my lord, the ordering portion. I am reading, my lord.
Where is your prayer in the writ petition? What is your prayer in the writ petition? And then an issue will arise till such time the proceeding is closed. How can you be granted a promotion?
But that's why the trial court directed this, my lord, the inquiry is, my lord, itself is deadlock. In this tale, because in 2003, they cannot, my lord, sit idle, my lord, like this, my lord, since 2003, we are in 2026. Now, my lord, after filing of the writ application, they have constituted the committee as to why they have caused the delay.
But that is, even if we exclude that, there is nothing to show that the proceeding concluded. It may be protracting inordinately for more than 2 decades. But neither you have taken steps to get it quashed or set aside on the ground of delay, nor they have closed it. So in such a circumstance, how a promotion can be granted?
No, my lord, the trial
without any challenge to the continuance of the proceeding for more than 2 decades.
Trial court directed them, my lord, to accept the closure of this, my lord. My prayer is, my lord, before your lordship.
Where is that direction by the trial court that the proceeding is set aside? How it can be granted in absence of a prayer in this regard? Where is your challenge to the continuance of the proceeding for more than 2 decades?
You see, because
come to the prayer where you have stated
I have paid, my lord, the promotion.
Promotion. How can you, knowing that the proceeding is pending?
Because, my lord, the 20 years, 30
Very well.
years,
Very well.
my lord, that was, my lord, the general conception of
Correct.
my lord, because they have not initiated, they have not reopened.
What do you mean reopen? It is never closed. What is the question of reopening?
No, 2003, they have closed inquiry officer. The inquiry officer closed the inquiry. Then, my lord, the disciplinary authority is to, my lord.
The officer did not close the inquiry. Inquiry officer was facing some difficulty. He sent it to the disciplinary authority.
So disciplinary authority never responded. So that means, well, it is presumed that it is
on presumption you have claimed the promotion. Very well.
Otherwise, my lord, 2003, my lord, how a person.
We understand what you are saying. Continuance of a proceeding for more than 2 decades, most undesirable.
My lord.
But till such time you seek a remedy in this respect, ignoring that pendency, how a promotion can be granted?
Because they have granted promotion to the other persons, those who are also in a similar circumstances.
So therefore, the illegality should be perpetuated by the court.
No, because they have not, my lord, questioned that part.
How does that?
My lord, kindly consider one thing.
You cannot.
My lord, we are, my lord, a batch of.
You cannot claim parity on the ground of an illegality.
No, my lord, there was a accident. Kindly see, my
others. We are not on that. We are it is a purely issue of law. You know, once a charge memo is issued or a charge sheet issued,
KV Janakiraman judgment is there. The proceeding, once it is initiated, you cannot be granted a promotion. At best, your consideration can be kept in a sealed cover to be opened after conclusion of the inquiry. All right, it has been pending for 25 years. That is,
I have now retired from service.
you never took any steps to get it set aside. That what is kept pending. And you ignore that, you say that give me a promotion, and the writ court has granted it.
No, the thing is, my lord, there was the accident. Kindly visualize the situation.
We are not on the matter. We hardly, that is hardly the concern of the court. We are saying it may be the most illogical proceeding.
My lord,
It may be a most illogical, not maintainable proceeding, but there has to be a declaration to that effect.
Then, my lord,
Does not have nullity written on its foot.
my lord, the judgment that, my lord, when the inquiry officer will send the report before the disciplinary authority, the disciplinary authority immediately, within a time-bound manner, will intimate whether he is accepting or disagreeing. What is such letter?
Very well. So we have understood. You presume that everything is over.
Otherwise, they would have, my lord, today, my lord, if he desired to reopen, my lord, is it, my lord, desirable? Now, after filing.
There is a question of reopening once there is a closure. You are presuming that there is a closure on the basis of page 107.
Can you see their letter in supplementary affidavit? Just, my lord, I understand from this letter.
No, what they are saying, we have seen it. They are asking this officer to inquire why it was pending for such a long time. Who is responsible? So it's not a reopening. It is to inquire why it is pending for such a long time. We have seen the
find out lapses in your delay in process and pointing out
why there is an inordinate delay in the proceeding. That is being inquired. They are not reopening anything.
So, but ultimately, my lord, the judgment of the Supreme Court has to be followed. I will show to your lordship judgment that when the disciplinary authority, my lord, good, bad, indifferent, filed a report before the disciplinary authority by the inquiry officer. What is the duty of the disciplinary authority? He has to respond. Either he will agree
that is already submitted.
So, my lord,
action taken on inquiry report is specified in every service regulation.
Every service regulation.
So there is only three logical consequences: acceptance, rejection, or further inquiry.
My lord.
He has to do one of the three. He has not done anything.
My lord.
So you presume everything is closed.
Yes.
That is what you are saying.
Yes.
That you have said.
My lord. Now, apart from
whether that is acceptable,
apart from this, because a group of persons was involved in this matter.
That is hardly material.
And my lord,
that's not material.
No, promotion has been granted.
You have to stand on your own facts and circumstances.
No, same facts. Kindly see, my lord, that
maybe we accept that it is same. You did not show. We accept that others have been granted.
So, my lord, they have granted. So now they cannot say either, my lord, they, my lord, argue on merit or, my lord, jurisdiction. Jurisdiction.
We are hearing both aspects of the matter.
Very well. Now, my lord, kindly, my lord, may I read the entire judgment, my lord?
No, we have gone through it. What is it you want to show from the judgment? You need not read.
No, my learned friend has not placed, my lord.
Sir, we have gone through. What is it from the judgment? Please point out.
Now, my lord, the trial court.
How the trial court considered that it was closed? Just read that line. The proceeding was closed.
Memo.
That is the only finding. If it is sustainable, then everything may be all right. If it is not sustainable, then you may have some difficulty. Come to paragraph 14 of the judgment.
Paragraph 4, my lord, start, my lord, may I read? My lord, short judgment, may I read the entire?
Please read paragraph 14, sir. Don't read the entire.
Very well, my lord. Office order dated such and such smacks of malafide. This one, my lord, that which was, my lord, filed through supplementary affidavit. There was no steps taken after
closing the inquiry on 19th August 2005. Yes. Now, where is this closure?
Because
please show where is 19th August 2005. Where is it?
In view of the above position.
Where is it? Which page?
107, my lord.
That is what is being relied upon. So this, whether this is a closure or not, that is the only issue before us. That is the only issue.
In view of the above position, IA feels that the inquiry officer or inquiry has been deadlocked and cannot be further proceeded. He has therefore no option but to close the inquiry at this very stage, and the case may be forwarded to the disciplinary authority CMD for taking views in this matter. So they have not taken any steps. And judgment, my lord, I will show to your lordships that, my lord, this kind of situation,
what are the, my lord, requirement is to be observed by the, my lord, disciplinary authority.
You need not show that this is a settled, this is every regulation has the same provision.
Because here
there is no regulation which has any provision otherwise.
So if he is disagreed, he has to, my lord, re-inquire, or he has to give the opportunity to the delinquent that I am not agreeing because of this reason. You reply to this.
Very well.
There was no further, my lord, communication from their part. Rather, my lord, they have promoted me in 2013. If it is not closed, how they have promoted me as well?
That promotion order.
My lord, kindly see. The 112. Number 1, serial number 1. It was issued by the Coal India Limited, that has been implemented by the Bharat Coking Coal Limited, page 114.
Very good. It's a lateral movement. It says horizontally placed. You are saying it's a promotion.
No, can you see?
Please read the third line. It's a lateral movement. It's not a promotion. If that was there, then maybe the concept of washing off would have applied. Once you are promoted, then everything prior thereto gets obliterated.
That's ultimately, my lord, they have not, my lord, taken any steps after 2006.
We have understood what you are saying. You need not repeat again and again.
And my lord, I have, my lord, submitted already that they have given promotions to the all others, those who have involved like me, my lord. And their names is features in the, my lord, that particular inquiry report.
We will only see whether 107 amounts to a closure or not. We are not sure yet, but we will see whether it can be taken.
And if it is not,
the inquiry officer under no regulation till now I have seen is given an option to close the proceeding.
but he can close the inquiry.
He can either hold the allegations proved, or he can hold it disproved, or he can say, I cannot proceed further. I need these documents. These things he can say. He cannot close the proceeding. He has to return a finding to the disciplinary authority. And it can only be closed by an order of the disciplinary authority. It starts with issuance of the charge memo by the disciplinary authority and closure by the disciplinary authority. So whether this order, which has been accepted by the learned single judge to be a closure,
there is a little bit difference. There is a difference. Closure of inquiry and closure of the disciplinary proceedings. Closure of inquiry is in the hand of the inquiry officer. Disciplinary proceedings.
Therefore, once the inquiry officer stops the proceeding, then the charge memo is over. It finishes.
That's that judgment of the Supreme Court.
So therefore, show us any
that judgment, my lord, today I have missed, my lord. Your lordship also knows. I will show to your lordship.
We don't know. If we knew, we would not be asking.
You know, this is an old judgment, 1984, something of banking is overseas matter. The Honorable Supreme Court said.
Right. Then you come with that judgment. We have heard the learned advocate for the parties. Full stop.
Number one.
Please, your lordship, my lord.
I am opposing.
This is my client's application. King is also in jurisdiction under section 151 for restoration of a matter. Which was, my lord, can you see the order which you are asking for? Recalling of or this order I am asking for. Please, my lord, take my petition.
May I make one submission, Malik? I believe, Malik, there is a condemnation application, Malik. But I would like to file an opposition to that.
The condemnation has no application here.
No, there's a section 5, I find. Malik.
Section 5 made, but has no application. Anyway,
If he wants to say that, if he wants to give away his section 5, I don't have a problem. But if he is relying on it, then Malik will kindly grant me one time.
Application.
584 days delay. According to their application, now if he says that it's not required, Malik, then obviously I will. If he's not pressing that application, then obviously, Malik, I will not ask for an opposition. That's his
matter appearing on the list for such a long
his
time.
mandate, Malik.
Power arrangement of it. Again, religion.
How soon can you file it?
7 days.
You have to constitute the bench again.
7 days, Malik.
7 days. So
Matter appearing on the list for so many days, but they knew they should have come late.
Just now, Mr. Mitra said that he might not also, it's not needed. I am giving him the, well, it's his option.
So let's not get into that. You
If it's
file it
7 days,
within a week.
Matter
File it within a week.
What the mind of says,
So we should keep it after a week, or you will reply to that. Otherwise, it will be adjourned for that.
Within 1 week.
He's saying within a week.
Within 3 days. But my lord.
A week. He's saying within a
We are
week.
saying reply within 3 days.
No. Whenever my lord fix a date, it's a broken bench, no?
I would require 7 days. After that, whatever time. And
So we'll keep it after 2 weeks.
Whenever convenient, your lordship, when my lord is
When your
sitting,
lordship
whenever it's convenient, your lordship sit together, give 1 day before that. 1 day before that, we shall file it.
Yes, as prayed by Leonard.
September, August.
We can fix it at 3 p.m.
3 p.m. Malik.
Yes, sir.
3 p.m. 3 নাগাদ যাচ্ছে 28 তারিখ 3 নাগাদ যাচ্ছে 3 তো
Strong point is
it's always it's whenever is that side.
But that is on a Friday.
No.
Friday. It's bound to be 3:30. It become a practice of the court.
On Monday.
3:30.
Oh, Monday, Tuesday, we have the festival.
Monday.
Then Wednesday after.
Friday.
Wednesday after
To 26, 26, 27.
Whatever convenient.
2nd September, 3 o'clock. Grateful.
Become a practice, good or bad. Bless you.
2 p.m. Malik.
No, 3.
3. Second at 3. Very grateful, Malik.
Monday.
Number 2 to 5.
My lord, I am in item number 4, my lord.
We are taken up 5.
My lord.
Who is appearing in the remaining matter?
My lord, on the last occasion, they are also not representing, my lord.
None of
But I only appeared, my lord. My lord, in respect of my lord, WPST 623 of 2002, arising of my lord, violation of
Span 519.
519.
What is the issue?
My lord, contempt application that was
Compliance of the choice.
my lord, compliance of the my lord, kindly take up the contempt application. My lord, order dated my lord, page 18 of my contempt application.
Span 519. Span 519. উপরে number was not good. No problem. This one. अच्छा वो
Date is the date of the order. My lord, order date is my lord, 11th August 2003, my lord. Page 18 of your lordship's order, contempt petition. My lord, this was my lord, contempt application has been my lord dismissed for default. I came before your lordship, my lord, with an restoration application along with the my lord, section 5
This is not
application.
this is not
Your lord-
CPAN 519 we are asking for.
Yes, yeah, multi-task.
And 11th August, ordered 11th August.
It's the order of the court.
Hearing the order.
WPST. WPST এর উপরে 2003 সালের অর্ডার।
Yes, this order is passed in CPAN,
My lord.
6/1/2005.
11th August 2003, my lord.
No, 11th August 2003. Where is that order? We are not able to.
Not in my contempt application, page 18, annexure P2. And on the last occasion, your lordships directed me to serve copy. But I have served, but the same has been returned back with an endorsement that is insufficient address or address is left. But I have filed.
Then how we can proceed?
My lord, if your lordships grants me liberty to, my lord, add the new incumbents.
You have to. No, we have got it. Thank you. You have to.
I have to ascertain the names, my lord.
You have already got it.
My lord, I will got it. But
you have got it or you will get it?
I will got it.
The learned advocate for the applicant.
Appearance.
Number 6. Item 6, I am for the state, my lord. I am led by learned government pleader.
What is the order?
This is an application for clarification, my lord, and a modification of your lordship's order. Now, my lord, in 2023, before going into the merits of the original application, in 2023, my lord, we had preferred a second writ petition, my lord, alleging inaction on the part of them. We wanted, my lord, expeditious disposal of our original application. During the pendency of the original application.
Before the SAT?
Before the State Administrative Tribunal. Now, my lord, during the pendency of that original application, the department, the respondent authorities concerned, my lord, came up with certain memo which was affecting us. So we came up before your lordship, my lord, at that time when the WPST was taken up by your lordship, and we wanted to show that memo. Your lordship said, no, since it is the court of first instance, you go up before that particular court. So lordship disposed of the matter on that day only. On the next day, the chairman of the learned chairman of the State Administrative Tribunal also retired. So your lordship said, possibly the new court will come up, you go there. Now, my lord, till date, that tribunal has not been set up. Now, my lord, that particular memo is contrary to the stand taken by the state. So, my lord, I assailed that memo in a writ petition because for the last 6 months, 10 months, for the last 10 months, that is affecting us. I went up before the Honorable Single Judge. The Honorable Single Judge, my lord, granted me liberty to approach your lordships. But these are the two orders, my lord, just placed before lordship. Application for clarification.
So the WP OA is pending since prior to the tribunal becoming non-functional.
2022.
So what have you filed?
But I'm just praying before your lordship because your lordship has directed in the your lordship may kindly takes up page 22 of my application for clarification. But today, my lord, I am not on merit of the case because the merit I have already assailed before the honorable single judge. If your lordship kindly comes to, my lord, at the bottom, my lord, of that page, having regard to the nature of claim raised being consequential benefits account of some claim proportion and considering the submission made on behalf of the petitioners, we find no such extraordinary urgent circumstance which may warrant interference or taking up of the matter by this court during pendency of the original application before the tribunal. The nature of the relief is merely consequential and no irreparable injury is involved. Mere pendency of the matter before a tribunal for some time, ipse facto, cannot be a ground for the High Court to take up the matters pending before the tribunal. Decisions of L. Chandra Kumar and Rajiv Kumar was quoted by my lords is clear in this regard. We therefore are not inclined to interfere in the matter for the present. We are informed that perhaps the sole member of the tribunal has retired yesterday. This immediate development also does not justify any difference in this OA. The writ petition is disposed of. Accordingly, can is also disposed of. There will be no order as to cause. This was passed by my lords on 9th of September 2025. Till date, tribunal has not been constituted. Now, my lordship may kindly comes to my lord page 40. Order dated 15 July 2026, my lord, passed by the honorable single judge. The affidavit of service filed today is taken on record. The petitioners are aggrieved by the acts of the commission and omission on the government of West Bengal. The grievances raised in this petition are also the subject matter before the WPST, which is presently without any quorum. On prior occasion, the instant grievances had been carried out to this honorable court by way of WPST. While disposing of this writ petition, the honorable division bench of this court had made the following observations. My lord's observation has been quoted. The situation has now been further aggravated due to that said tribunal being without a quorum for almost 10 months now. Another division bench of this honorable court, my lord's order passed in Anindo Sundar Das has been quoted, my lord.
209.
209. Lordship's judgment has been quoted that this honorable court has the power to take. My lord, so and so appearing for the petitioners in the circumstances aforementioned prays for an adjournment for some time to enable him to approach the honorable division bench of this honorable court to seek clarification in respect of the issue pertaining to the invocation of the jurisdiction of this honorable court under Article 226 in this matter, WPA 14872 of 2026. Now, the state raised a point that this point cannot be raised before the honorable single judge. This was the point.
Do you want to file a writ?
But I've already filed a writ. The state took a point that you cannot take this point before the honorable single judge on the ground that this point was already taken before the honorable division bench. The honorable single bench said you just go there, make an application there, come up with a clarification, I will take up the matter.
Perhaps not. But the issue is that if you will go through 209 judgment, what we have delivered, we have said that if the matter is pending since prior to retirement, if it is pending since prior to the tribunal becoming non-functional, then you will have to file a writ here in the division bench. If there is a cause of action after the tribunal becoming non-functional, then only you will go before the learned single judge. So therefore, the writ petition was required to be filed before the division bench. The single judge bench cannot assume jurisdiction.
The development, my lord, subject to correction, the development which took place in connection with the original application when they took out that particular memo, that was after, my lord, the tribunal was, the single judge was, single member was.
It was functional till then.
Single member was.
Orders were being passed.
Orders were.
On the day we took it up, the person said it has been, so said what, maybe we didn't know that it will continue for such a long time. So now that it has continued,
then my lord, I'll do one thing. I'll bring the entire writ petition before your lordship.
You will have to file it afresh. Before the division bench, you will have to see. You will have to frame the relief accordingly. Some orders of the tribunal will have to
by that.
But I've seen that. But I was also on the, it was the honorable.
In a subsisting cause, my lord has held, in a subsisting cause, my lord, the division bench has to be approached. If it is a fresh cause arising after the vacation.
Welcome, dear Lordship. Welcome. But I have a very, my lord, my learned senior
I
friend
had
was,
the privilege of raising the issue before the learned single judge, which
well, it was more on merit subject to correction. And I have a very good case on merits. I'll come back to your Lordship. I am also of the view.
Whichever matter came up, we dealt with it accordingly. But in one case, the state has raised the objection.
No.
Then we had to decide it in 209. Now, once we have decided it, as of now, it is binding on all of us.
Lordship has adjourned this matter.
Yes, on second, we have this bench is likely to resume on second.
Second, but that is not 7th September. Second. Grateful.